Good morning, everybody. It is March 25th, 2026. You have found yourself to the full Commerce Committee. As we see the sun rising higher in the air, spring fever is about to hit. I just wanted to make a very important announcement today is that we will not be allowing the signing of yearbooks during this committee time today. I've instructed our Sergeant at Arms, if anybody's autographing yearbooks, to just take them up and hold them until next week when you will be authorized to sign yearbooks because, yes, folks, this is not our last meeting. You'll see us again next week. So just put that in on your calendar. But if we see them today, we're going to have to take them. You prepared, Mr. Sanders? All right, good deal. All right, we've got an action-packed calendar today. We're going to be hitting all the high points of commercial activities within our great state. Housekeeping items before we get started. We're going to roll item number 13, which is House Bill 846, to the Hill at the request of the sponsor. House Bill 846, roll to the Hill without objection. Before we get started, our man of order, Chairman Jerome Moon, has reminded me that we have not signed in to take roll, folks. I'm so excited today. I'm so excited that I forgot to take roll. I just wanted decorum, leader. I wanted things in this committee to run smoothly, and I didn't want to see people passing around contraband. If we could sign in, we've got the roll call up on your screen. Hit the blue lights, and let's see who's here. Madam Clerk, can you tell me whether that's a quorum? It looks like one to me.
Mr. Chair, you have 17 members present. You have a quorum.
All righty, good deal. First up on our calendar today is House Bill 1898. House Bill 1898 by Deputy Speaker Zachary. Got a motion and a second. We've got a few amendments here. Deputy Speaker, what do you think?
Yes, sir, Mr. Chairman. I believe we're going to go with 16460.
All righty, we got a motion. There's a second. All those in favor of attaching Amendment 3 to get this discussion started, please signify by saying aye.
Aye.
Any opposed, no. Hearing none. Your bill is amended, sir. Tell us about it.
Thank you, Mr. Chairman and committee. Members, it's good to bring a bill to you that roughly 90% of Tennesseans support, according to Anchor Research. This is the AI protection bill. AI has been in the news quite a bit over the last couple of months, specifically since December, since the White House issued their executive order. And I can tell you with certainty that what we're doing in this legislation does not in any way conflict with what the White House, the executive order they issued. Section 8 of that executive order in December carved out exceptions for child protection, catastrophic risks, and we address that here. So members, we're working to be proactive and be a national leader when it comes to protections related to AI. Again, as I mentioned, our speaker was at the White House a couple of weeks ago, and they actually referenced this bill specifically. The legislation establishes clear transparency and safety requirements for the largest and most powerful AI companies in Tennessee. We're putting in place guardrails focusing on these two high-risk areas: catastrophic public safety risk by frontier AI models. And the frontier AI models, there's 5, and you know all the names: xAI, OpenAI, Meta, Google, and Anthropic. Catastrophic risk includes cyber attacks, loss of control, which I do call the Skynet provision. Some of you will get that if you're paying attention. Thank you, Leader Cochran and Leader Camper, for getting that. Weapons assistance or large-scale physical or economic harm. But most importantly, Mr. Chairman, we focus on child safety risk posed by chatbots who interact with minors. Currently, listen to this, members, currently 2 out of 3 teens use AI 30% of them use it every single day. And so many legislatures were late to the game in protecting children from social media. We're not going to make that mistake with AI. Some of those challenges we've seen with AI related to children encourage self-harm. Many aspects have caused severe emotional distress. And Mr. Chairman and members, we're going to again address that with this legislation. So finally, Mr. Chairman, this legislation does a couple of things. Requires AI companies to simply publish and implement and comply with their own plans for how they manage catastrophic risk, and also how they'll manage the risk to children. The company must make their guidelines clear while continually updating and modifying that. And Mr. Chairman, that's one of the things we did, as I mentioned to you and Chairman Darby in the subcommittee with the amendment, is there were some questions related to substantial modifications and when those needed to be made. So we addressed that. If there is a safety incident, the Frontier developer must report to the AG, who has sole discretion of enforcement, within 15 days. If the incident poses imminent risk of death or physical injury, the report must be made in 24 hours. The AG has sole authority to bring penalties and violation. Finally, Mr. Chairman, thank you for your patience. This legislation makes very clear that the federal government passes similar requirements or takes an additional step. Mr. Chairman, you and I have discussed this. I believe March 20th, they put out a national AI legislative framework, hoping that Congress will someday act. We're not going to hold on our hope for them to do anything, but hoping that Congress will act. This does not supersede that. And any of these AI models, the Frontier models or chatbots, will be in compliance if they take those changes federally. So with that, Mr. Chairman, last thing, promise is the last thing. Spectrum and Comcast, as I mentioned to you in subcommittee, they asked for some clarification related to customer service and some other aspects just to provide clarity. All the stakeholders got together. They worked that out. So we appreciate everybody coming together. Motion picture industry, Comcast, Spectrum, everybody's on the same page for the most part, Mr. Chairman. So with that, I'll be glad to answer your questions.
Thank you, sir. Before I've got a question. If anybody else, I don't see any hands up, but I do want to say it is wonderful to see my good friend, Representative G.A. Hardaway, in attendance today. It is great to see you, my friend. Okay, Deputy Speaker, you and I talked about this, and I told you that when I was in the Beast on the way to Graceland on Monday with the president, he asked me about this legislation.
No doubt.
And he asked me if I'd seen his directive that came out on Friday, not even the one in December, but on Friday. And let me read you a little bit to this, because I think it's important that we all know what we're doing here. Importantly, speaking of AI model, the White House has not issued model legislation, which I think they may enjoy yours enough. But it says, importantly, the framework can only succeed if it is applied uniformly across the United States. A patchwork of conflicting state laws would undermine American innovation and our ability to lead in the global AI race. The federal government is uniquely positioned to set a consistent national policy that enables us to win the AI race and deliver its benefits to the American people while effectively addressing the policy challenges that, wow, you can tell this is Washington, D.C., they got big words. Policy challenges that accompany this transformative technology. The administration looks forward to working with Congress in the coming months to turn this framework into legislation that the president can sign. So I think with so many state houses and general assemblies in session across the United States, it seems like he was telling everybody to pump the brakes. But I want to make sure that our members, that you can give us clearance that through the communications that you've had, that this bill does not conflict with what came out on Friday.
Thank you, Mr. Chairman. Very good points. And yes, sir, thank you for bringing that up and going a little further in the detail. Yes, so members, just for absolute simplicity, if you look on page 9 and 10 of the legislation, it makes clear that any company will be seen in compliance with what we've done here, and we in no way are superseding federal government. We're providing space for Congress to act if they choose to do so, and in no way would this conflict with that. And Mr. Chairman, I was able to confirm with the Speaker this morning that he did confirm with the White House they are good with us with this legislation. I'm not going to say supporting, but they're good with the steps we're taking moving forward and looking forward to the language that we actually pass.
Understood. I appreciate that. And then also one thing that I think that I don't believe that the new amendment took out, but if it did, please correct me, and that is that we are authorizing our Attorney General, which is the office here within the administration that deals day to day with AI challenges. And I know that I've had numerous conversations with General Skrmetti and his staff who've done a good job of following the evolution of AI. And their number one goal is the protection of our young people throughout the state. So we do offer them the ability to set rules within the framework of your legislation. Is that correct?
Yes, sir. Thank you, Mr. Chairman. Yes. So working with you and Chairman Darby, that first amendment we put on in sub made it crystal clear that sole discretion rests with them. And then they actually have the ability, and we require them to work with the TBI, Department of Safety, to promulgate additional rules that, again, will come before this body because this is an ever evolving issue. And so, yes, sir. Thank you, Mr. Chairman. Sole discretion rests with the AG.
Thank you, sir. This is one of the more challenging pieces of legislation that one of the more challenging issues that this legislative body has to deal with, because how do we encourage innovation and keep a light touch on regulation, yet still protect the vulnerable and innocent? So thank you for walking the tightrope. Stand by. Deputy Speaker Zachary, we need to put that amendment on. It didn't get picked up in the last draft. And so our ever capable legal staff has said, hey, if that's what you guys want, motion. Second. The number, I believe, is that 16203, Deputy Speaker?
The AG amendment specifically is 15780.
All right. That's
Yeah,
amendment
thank
number
you.
one.
Yes,
Okay.
sir. Thank you.
All right. Let's adopt that, because I think that's critical to rounding out this piece of
Absolutely.
legislation. We've got a motion. We've got a second. All those in favor of adopting it, please say aye.
Aye.
Any opposed, no. Great catch to our legal
Yes,
department.
thank you.
That amendment is attached. Now then, seeing no other further discussion, we've got everything in order, I believe. Let's vote on House Bill 1898 as amended. Madam Clerk, please open the board. Madam Clerk, close the board. Give us the results, please.
Mr. Chair, you have 20 ayes and 0 nays.
And with that, House Bill 1898 is on its way to government operations.
Thank you, Mr. Chairman, Committee.
Next on our calendar today, House Bill 569 by Chairman Farmer. Come on down, Chairman Farmer. Got a motion and a second. I see we've got some amendments to consider.
Yeah, thank you, Mr. Chairman Committee. Chairman Vaughn, if we could look at House Amendment 15999.
All right. We got a motion and second on House Bill 1599. Let's get that amendment attached. All those in favor, please signify by saying aye. Aye. Any opposed, no. Seeing none. Your amended bill. Tell us what we're doing here, Representative Farmer, or Chairman Farmer. We've had plenty of discussions about this bill.
We have, and I appreciate the indulgence of the committee, Mr. Chair, and members. And what this bill does, it provides transparency and oversight to the consumer in the title insurance industry. For example, right now, if title companies want to share premiums with other title companies, they can do so without the consumer even knowing. It would be almost like me sharing a fee with another lawyer without advising my client to do so. And that's against my ethical rules of conduct to do that as an attorney. Title companies are insured and bonded and underwritten. I think they should be held to the same standards that other professional organizations are as well. And the consumer, the most importantly, should have the opportunity to know where their money is going and what they're paying for, and what title company that is issuing the premium, which title company can actually provide that the liability protection and that policy if the policy is needed. So that's what this bill does. I'll be happy to answer any questions that y'all may have.
Thank you, sir. I know that in Business and Utilities, Chairman Grills and the committee examined this thing inside and out, had some very spirited discussion on it. I don't see any hands up about this new transparency bill. Leader Camper.
Thank you, Mr. Chairman. Chairman Farmer, there was a lot of discussion in subcommittee and a lot of concerns from testimony in subcommittee. Are you saying now with this amendment that we put on that some of the issues that came up are addressed now in this amendment, that people came to the table to deliberate and come up with something that everybody could agree with?
Chairman Farmer.
Thank you, Mr. Chair. And the answer is no to that, but we were able to alleviate the concerns of the underwriters, how we restructured this amendment. It handled their concerns. I don't see anyone from the opposition from the other side of here today. So we are where we are right now, and I'm confident this is a good piece of legislation that's going to bode well for Tennesseans.
Chairman,
Oh, that's okay.
Leader Camper, I want to interject something because,
Okay.
again, this is one that we've had, I've had a lot of discussions in my office about it, and kind of this is where we landed on this. And that is that East Tennessee and West Tennessee, as you remember in the testimony, did things one way and Middle Tennessee did another. We are not outlawing, we're not making it against the law what the people of Middle Tennessee do in this industry. All we're requiring them to do is to disclose to the consumer that that's how they operate. And so that is where we are now with this bill. And we think that that will provide the transparency that we think when people are involved with some of the largest investments of their life, that it's important that they know where the money is going. Because before they did not know exactly, they had no reason to ask, but this lets them know how the money is being split so that if they have an issue with it, then they can take exception to it. Is that a fair statement,
It
Bill
is, and,
Sponsor?
Thank you, Mr. Chairman, for that. It also makes it clear where the liability lies. So if you have an issue, it makes it very clear who you go to file that claim with your title insurance company.
Thank you.
Leader Camper.
Thank you. That was my other question, because although you are divulging that both can, the person is still going to want to know who's responsible for what. And it seems to me that that's addressed in this new amendment. And the chairman just mentioned it will not have an effect on how we operate in West Tennessee or East Tennessee for that matter. And that is a true statement. And so those issues have been alleviated. Can you talk to, you said the underwriters are okay now. I can't remember what their real issue was, but they're okay with the bill. Everything is good to go now. Is that
Chairman
what I'm
Farmer.
hearing?
Yeah, thank you, Mr. Chair. And just quickly, I'll say this, that the original bill required that they acknowledge and agree for these companies to share the liability. What we did, we struck that. And then we just make clear in this legislation that who cannot accept liability. So it's only the issuing title company that has the ability to accept the liability because they're the ones issuing the policy.
That's right.
The other title company can't.
Okay,
So that's how we handle that.
okay. Thank you,
We
Mr.
good,
Chair.
Leader?
Thank you, Mr. Chair. Yes, thank you, Chair.
Representative Hemmer.
Thank you, Mr. Chair. Thank you, sponsor. I previously got reached out to by a title attorney in my district who's had some concerns about it. Not sure those got demurred, but just curious from where this amendment stands now. If I'm closing on a house, I'm still able to choose my own title attorney, and if the seller wanted to choose a separate one on the other side of the transaction, that's still able to occur.
Chairman Farmer.
Thank you, Mr. Chair. Yes, you absolutely have the right to choose your own title company. And that's once you draft that purchase agreement, your offer, just be sure to put what title company you want to use in there. And that's part of the negotiations. You can still do that. That's the way it's been done.
Representative Hemmer, thank you. You're taken care of. Any other questions? Seeing none, hearing no one calling my name, we will vote on House Bill 569. All those in favor, please, Madam Clerk, open the board, please, and then we'll hit that green button. Thank you. Everybody vote on House Bill 569 while the board is open. Madam Clerk, close the board, take the roll. Take the vote, excuse me.
Mr. Chair, you have 19 ayes, 0 nays, and 2 present not voting.
All righty. Chairman Farmer, you are off too, calendar and rules.
Thank you.
But not right now. Right now, you're.
I'm not leaving.
Let me restate that. House Bill 569 is off to calendar and rules, but you're staying right here to talk to us about House Bill 1970.
Awesome.
All right, you're in proper posture. I think we've got an amendment, and I think we're going to consider amendment number 3016537. Do I have the correct information? We got a motion and a second on that. Let's get that adopted first. All those in favor of placing amendment coded 016537 onto House Bill 1970, please signify by saying aye. Aye. All opposed? Hearing none? You are in proper posture. Chairman Farmer, please tell us what we're doing.
Thank you, Mr. Chair. If we could go to Leader Cochran, that's his friendly amendment there.
All righty, thank you. Leader Cochran, you're recognized.
Thank you, Mr. Chairman. Thank you, sponsor. Yes, hey, this is, I appreciate the collaborative effort on this one. This is an attempt to maybe to fix something that we did last year. This is allowing licensed attorneys to also prepare a deed. This amendment does have the clarifying language that they would have to utilize a survey prepared by a licensed land surveyor. So it's making sure that the land surveyors are still very much involved in the process, but still allowing those attorneys to prepare the deed. So we've got numerous folks working on those deeds.
Thank you, sir. And now that is the extent of this bill.
That's a great question. Yes, this completely rewrites the bill. This is the only thing that this bill does at this point.
Thank you, sir. So all of the gnashing of teeth going on out in the title industry, everybody can take a break for at least a year and give us your thoughts and concerns about how to help us make sure that these fraudulent transactions can get addressed in a proper scope. But right now, this bill does nothing but fix a problem that Leader Cochran had brought to his attention in previous code. And so that's what we will be voting on when Madam Clerk opens the board. So would you do so, Madam Clerk? I believe that does it. Madam Clerk, would you close the board and call the vote?
Mr. Chair, you have 20 ayes and 0 nays.
That sounds like a victory. Chairman Farmer,
Thank you.
thanks for being with us today.
I appreciate it. Thank you, Mr. Chair, members. Appreciate it.
And House Bill 1970 is on its way to calendar and rules.
All right.
Chairman Baum, there's Chairman Baum. Got a motion and a second on House Bill 2408. Chairman Baum, why don't you talk to us about it?
Yes, good morning, committee and members. This is a bill that addresses what I would call the annoyance economy. The annoyance economy is becoming a formal term that means where corporations profit by making things inconvenient for consumers. For example, companies are making it harder to redeem coupons. They're making it harder to claim reimbursements from warranties when products are defective. And another element of the annoyance economy is where companies call continuously with robocalls peddling their services and merchandise. What this bill would do is it would limit these kinds of robocalls in Tennessee to no more than 10,000 per month to residential households. And violations of this would be a violation of the Tennessee Consumer Protection Act. Give a quick personal story. My father's 88 years old, and he literally gets calls all day long trying to sell him end-of-life insurance, alarm systems, med alert devices. And since I happen to have his exact same name, they think I am 88 years old as well, and they call me all day long trying to sell me the exact same products. We already have a federal do not call list, but it evidently is not effective. And so what this bill is designed to do is to kind of take another approach at trying to reduce these robocalls.
All right, we have an entire cadre of amendments that are offered for our selection, Chairman Baum, but we'll ask you, how would you like to see one of these bills, your bills amended here?
My favorite amendment is 016462.
That 016462. We got a motion, we have a second. Let's vote on that and then we'll see, we'll get it amended, then we'll see if any of our committee has any questions for you. All those in favor of attaching amendment coded 016462 to House Bill 2408, please signify by saying aye. All opposed, noes, hearing none. Your bill's amended. We'll open it up for questions, committee. Does anybody have any questions? Yes, Representative Lynn.
Thank you, Mr. Chairman. This certainly for the consumer would be asymmetric information. They have no idea how to find out how many times who's ever calling them has called other consumers. So what is the enforcement or reporting mechanism on this bill? And I guess also the enforcement mechanism. Is it from the consumer, or does the state have to monitor this? How is this done?
Mr. Sponsor.
Both. It would include a reporting mechanism where the number of calls by these solicitors would need to be reported to the Tennessee Public Utility Commission. And then in conjunction with the Tennessee Attorney General, the Attorney General would have the opportunity to enforce the provisions under the Tennessee Protection Act. Each violation would be $1,000 in cost. So it would involve some reporting, some penalties. It would involve TPUC, and it would involve the Attorney General.
Follow up?
So you're saying that if a consumer was very diligent and they reported and reported and reported, the Attorney General's office might notice, hey, that company didn't report to us, and then they can go after that company.
Mr. Sponsor.
I think that's one way, but I do think you're right. One individual consumer would not necessarily know. I can see how they wouldn't know whether the law was being violated or not. But hopefully through the reporting mechanism, the Attorney General would have a good sense of whether the law was being violated.
And just one follow-up.
Oh, sure.
Thank you.
I find this line riveting.
Thank you, Mr. Chairman. So my last question is, our Attorney General, I'm sure, has authority in our state, but what about any of these phone calls that are coming from out of state or even out of the country? I know that I'll see that on my phone a lot.
Mr. Sponsor.
I'm sure the enforcement of this by the Attorney General would involve things like, can you track down the violators? Are they in the country? Can you get their identity? And those are enforcement mechanisms that I hope the Attorney General knows all about. I don't know what all the mechanisms are at his disposal.
Thank you, sir. Any other questions? I think this is one of those cases to where I think that, frankly, technology advances faster than our ability to regulate it in some cases. I saw Vice Chairman Bricken with his hand up.
Thank you, Mr. Chairman. And to the sponsor, 10,000 a year coming into Tennessee on a calendar year basis, is that the number?
Mr. Sponsor.
I hope I said 10,000 per month
Oh, 10,000 per month?
to Tennessee residential households.
Okay. And just curious, where did the 10,000 come from?
Mr. Sponsor.
It was a limit that we felt like would allow some companies and corporations to advertise their products to a reasonable extent, but would limit it to where it would prevent you from getting 6 to 10 calls per day selling MedAlert devices.
You good? All right. Representative Hemmer.
Thank you, Mr. Chairman. Thank you, sponsor, for bringing this. It was a good discussion in sub about it. And I appreciate you working on this thorny topic. A question I had for you was, I've worked with the PUC and Attorney General for a lot of times when people are, sending texts around purchasing homes. And so they found out there's kind of a loophole. If you're on the do not call list right now, it's for selling, not offering to buy for something. So my question for you is, would this cover if someone was sending, over 10,000 calls per month, offering, to buy your house, or just offering a service versus trying to sell you something?
Mr. Sponsor.
There's a section of the code that establishes business relationships between a company and its customers. And this law would not place the 10,000 per month limit on existing business relationships. So that if you're Walgreens, as an example, and you've got customers who like it when you call them to tell them that their prescription is ready to be picked up, this bill, this proposed legislation wouldn't affect those type of phone calls, because there's an existing business relationship. So that if you're in some type of real estate sales and you've got customers who are interested in getting information from you about houses that are available, that would be the kind of business relationship, existing business relationship, that would not be covered by this legislation. And that definition is not repeated in the amendment, because it's already established in another section of code where, again, existing business relationships wouldn't be impacted by this bill.
Another question?
Thank you. So just to clarify, if I didn't have a relationship with a company and they were texting me and 10,000 of my friends a month, then that they would potentially be, liable in this legislation.
Mr. Sponsor.
If there weren't an existing business relationship, the calls would be impacted. And I know we talked in subcommittee about texts. In subcommittee, there was a different amendment on the bill that would have covered text. This particular version of the bill does not cover texts. It was amended to account for a couple of concerns of stakeholders.
No further questions. All right. Seeing no more hands up, I think it's time for us. Wait, I've got Chairman Grills down here.
Thank you, Mr. Chairman. Just curious, how is this going to affect the political world and the political calls that come out every August and November or October of an election cycle?
Mr. Sponsor.
Thank you. That's a good question. We're going to have some folks running for governor, for example, and they'll be wanting to call a lot of potential voters. They would also not be affected by this legislation. Political phone calls are covered under a different part of our code that provides them with free speech rights to get out their political messages. And so this would not limit campaigns.
Chairman Grills.
Thank you, Mr. Chairman. So the perception is that politicians can skirt the law. I'm just playing devil's advocate here with you. But the business world would not be able to. How do you think that's going to go over?
Mr. Sponsor.
Well, asking about the implications for political campaigns was actually one of the first questions that we ask in this process. And evidently, they are covered by different parts of the code so that they're not impacted. And the rationale for that is free speech, First Amendment. Campaigns have the right to get their message out under the First Amendment. But the First Amendment evidently doesn't cover advertisements.
Thank you, Mr. Chairman.
Chairman Grills.
And I appreciate and applaud you for this. I have several older folks at the back of my district that will call me on a regular basis, not 10,000 times a month, but they call and they complain about this problem here. I mean, all hours of the day, they're constantly getting someone harassing them, trying to sell and harass. But thank you for your effort.
Thank you, sir. I appreciate it too. I can remember my dad in his waning years always felt oppressed by direct mail. I couldn't imagine how he would stand up under the onslaught of the telephone solicitations that people receive today. So let's vote on this for Chairman Baum, would you? I see no objections. Madam Clerk, would you open the board on House Bill 2408, please? Would you close the board and call the vote, please, ma'am?
Mr. Chair, you have 19 ayes and 0 nays.
All righty, and with that vote, House Bill 2408 is headed to GovOps.
Thank you all.
But you're not headed to GovOps. You're staying right here with us. Chairman Baum for House Bill 1447. Motion and a second. You are in proper standing. I see a number of amendments, sir.
Yes, this is a sign of fruitful discussions and negotiations. I am interested in Amendment 016548, which I believe is a late filed amendment.
Well, we are sticklers for timely filed amendment, except one time a year. And what time of year is that, former Chairman Boyd?
Motion we accept untimely filed amendments.
Oh, well, how about that? Do I hear a second? All those in favor of accepting untimely filed amendments because we're on our final calendar, please signify by saying aye. Any opposed, no? Hey, let's consider that amendment, even if it is untimely. How about House Bill 016548? Do I hear a motion on that? I got a motion. I've got a second. All those in favor of attaching Amendment 3, which is coded 016548, a formerly untimely filed amendment to House Bill 1447, please signify by saying aye. Let's hope there's no no's, because that was a pretty low-key rumble on an aye. Any no's? Hearing none. Your bill's amended. Sir, please tell us about it, Mr. Sponsor.
Thank you, Chairman Vaughn. And this amendment would rewrite the bill. What it would do is it would give the treasurer legislative authorization to apply to serve as a non-bank custodian of Trump accounts. It would not give the treasurer the ability to set up such a program, he would have to come back to the General Assembly for that authority. And let me just briefly remind you of what a Trump account is. It is where individuals born between 2025 and 2028 young kids will be set up with IRA type tax deferred accounts where the government will contribute $1,000. Dell Computers might contribute an additional $250 on top of that. And parents can contribute up to $5,000 per year. This money will grow tax deferred, and upon the child turning 18 years of age, they can then use this money for education or other purposes, or continue to save for retirement.
I'd like to thank the sponsor for putting this bill back on notice. We were, you know how sometimes early in session, the winds blow cold, they come sweeping down the plateau, and they're a little chilly to things. However, as we try to stay current with the times, our treasurer sought your leadership on this matter and said, hey, you have a vehicle that maybe we can gain some good out of with regards to what's coming down the pike, perhaps federally. And you brought this bill, you amended this bill and put it back on notice for our consideration. So thank you for doing that. Do we have any further questions? Chairman Grills.
Thank you, Mr. Chairman. And just for the record, the state is not on the hook for any amount of dollars going forward or going backward, correct?
Chairman Baum.
That's correct. The state of Tennessee would not be contributing to these accounts. The federal government would, but I should also maybe add that the state would not be creating the Trump accounts program under this bill. The treasurer would still have to come back in front of the General Assembly for that authorization. This just gives the treasurer the ability to apply to be the custodian to kind of start the process.
Chairman Grills.
Thank you, Mr. Chairman. And this would not give the treasurer the authority to create any accounts outside of the Trump accounts either. Is that correct?
Chairman Baum.
Correct.
Okay. Thank you, Mr. Chairman.
I see Representative Lafferty's hand up. Chairman Lafferty, you're recognized.
Thank you, Chairman. And this in no way prevents others from being custodians for these Trump accounts, correct? Like Ameriprise or Prudential, any of these other financial firms?
Mr. Sponsor.
Correct. It would not prevent them.
Okay, thank you.
Representative Vital, saw your hand up.
Thank you, Mr. Chairman, and thank you, sponsor, for bringing this bill. I think it's good. It's a good opportunity for the treasurer to create the opportunity for savings if this program does develop with the federal government. My question is, if the treasury was the depository custodian, and let's say that account accumulated for 10 years, and there was $100,000 in that account, hypothetically, could they then choose to transfer that to another custodian, i.e. a bank or an investment company, or would they be locked in to use the treasury for life?
Mr. Sponsor.
I do not think they would be locked in. I think they would have the option to partner with investors and advisors in the private sector. This would just get the process started. And after the process gets started, the treasurer would have the responsibility of developing things like administrative procedures and how the accounts are going to be managed.
Thank you. And I'm sure there's a lot to be worked out. I'm just curious on the longevity of the program and its management. Thank you.
Do we have any further questions of the sponsor? I see Leader Camper's hand. Well, I didn't see it, but my trusted assistant
okay.
did. So
Thank
you're
you, Mr.
recognized,
Chairman.
Leader.
Thank you, Mr. Chairman. Representative Baum, the amendment we just put on rewrote the bill, correct? Because there was a lot of discussion about, government versus private and all of this deliberation. So did this amendment just rewrite the entire bill and we're only giving the treasurer the authority to do something?
Mr. Sponsor.
Yes, the amendment rewrote the bill. It took out the first section, which had to do with setting up retirement accounts for workers in the private sector. That's not in the bill any longer.
Okay.
It kept the part of the bill that dealt with the Trump accounts, which are really more IRA type savings accounts for newborns up to the age of 18. And in that second section, it just authorizes the treasurer to apply to be a custodian of those accounts. It doesn't actually even set up the plan.
Leader Camper.
And it still does not put the treasurer in a position where he's competing with private industry. Is that correct as well?
Well, I like that question. Along the lines of Chairman Lafferty's, I think it's very important that we repeat this answer.
Yeah, it
Mr.
is.
Sponsor.
It's
This bill
important.
would not give him the authorization to do that. He would just have the authorization legislatively to apply to be a custodian. The plan itself would not have been set up yet. And in fact, the treasurer would have to come back to the Tennessee General Assembly to get that plan approved.
And Leader, I think what we're doing here, and the sponsor can correct me if I'm wrong. There are some segments of our population that do not have relationships existing with investment advisors. But yet, if there is an opportunity for a kind of a universal savings program to be offered to them, we're setting up the statutory framework to where the state treasurer can step in and originate an account so that they also get to take advantage, even though they don't have an advisor. And then at that point, I would assume somewhere down the road, they could come out of that program and move to an advisor. Am I correct in that, Chairman Baum?
I think so, but this amendment doesn't even actually set up the program yet. We're stopping even a step before what we discussed a week ago in subcommittee. The treasurer would have to come back with his plan to the General Assembly for approval. This just gives him the ability to start the process by applying to be an eligible custodian of those accounts, needing approval, I guess, from us legislatively, but then also from the federal government.
All right, thank you. Leader Camper,
Okay, well,
make this a
thank you,
good one because we need to remember your question asking for a while after this.
Well, there you have it. I think the treasurer does a great job in investing our money. I think if you look at the treasurer's earnings, in the current budget is over $140 million. So I don't have a problem with the treasurer, being involved in it to that end. But thank you, Mr. Chairman. Thank you, Chairman Baum.
Representative Hardaway, it's been a while since we've heard your voice. Please let us know what's on your mind.
Thank you. To the presenter, is there an educational aspect to this, both for the parents or guardians and in the actual academic process, LEAs or community colleges, four-year colleges?
Chairman Baum.
Thank you, Chairman Vaughn. There's not an educational aspect in this particular bill, but we did pass legislation last year that allowed the treasurer to go around the state with a financial literacy initiative. And he actually came to Rutherford County. He was in Smyrna, where he talked to a large group of commissioners and school board members and parents and employers, trying to get the word out about the importance of financial literacy. And so with other bills, we have started that process, and I should brag on the treasurer. He is using that legislation to travel around the state. He's been to my county.
Thank you, sir.
And Mr. Chairman,
All right.
the presenter can brag on me if he wants to.
I'm thrilled you're back.
All right. And I've got in front of you, Chairman Clemens, I got Chairman Powers. But I got your hand up. Chairman Powers.
Thank you, Mr. Chairman. I move previous question.
I've got one. I've got two. I've got three. We're going to put this on the board. All those in favor of the question being called, please signify by punching the green. Well, open the board, Madam Clerk, if you would. We'll put this one on the board. Anybody vote you? Anybody want to change their vote? Madam Clerk, close the board, call the roll, or call the vote.
Mr. Chair, you have 16 ayes and 4 nays.
All right, motion of previous question passed. Therefore, we will vote on House Bill 1447 as amended by Amendment 3. All those in favor, please signify once the Madam Clerk opens the board. Thank you, Madam Clerk. Would you close the board and call the vote?
Mr. Chair, you have 15 ayes, 2 nays, and 3 present not voting.
All right, with that, Chairman Baum, your bill, House Bill 1447, passes and is off to GovOps.
Thank you all.
Hello, Representative Butler. Come on down. Tell us about House Bill 2334, sir. I got a motion. I got a second. We see that you're offering an assortment of amendments here today, too. Which ones would you like to have attached, sir?
Thank you, Mr. Chairman. We just want to attach 015293 that we attached in subcommittee. We want to stick with that amendment and that amendment only.
Motion second on amendment number 1. Any discussion on amendment 1? Seeing none, all those in favor, please signify by saying aye. Aye. Any opposed, no. The ayes have it.
Oh, easy there, Mr. Chairman.
Excuse me. I learned my gabbling skills from the late Gerald McCormick. All right, sir, we have your bill amended. Let's talk about some boilers and elevators and amusement devices, sir.
Thank you, Mr. Chairman. So this legislation is actually to make government work better for our Tennessee citizens. By doing that, to do that, we will be moving the elevator division, the amusement division, and the boiler inspection, those divisions from the Department of Labor to the Department of Commerce. And with that said, Mr. Chairman, we have worked with both commissioners and the governor's office to work out the details. The Department of Labor will be required in this legislation to provide all of the necessary information to the Department of Commerce by November the 15th of this year. And the Department of Commerce will implement this and take over all of those divisions on July 1st of 2027. With that, Mr. Chairman, I'll be glad to answer any questions.
All right, sir. Hey there, Speaker Pro Tem Marsh, you had your hand up.
Thank you, Mr. Chairman. And I'd like to ask Mr. Representative, why was Labor ever given this authority in the first place?
The $10,000 question, Mr. Sponsor.
Thank you, Mr. Chairman. I asked the same question when I realized that the elevators were under Labor. I asked why that, and nobody has been able to give me an answer on how they got over there, or even boilers got over there for that matter, or amusement devices got into the Department of Labor. So that might be the $100,000 question, Mr. Chairman.
All righty, thank you. Does anybody have any further questions for our sponsor? Seeing none. Madam Clerk, would you open the board and let us vote on House Bill 2334 as amended? Madam Clerk, close the board and give us the vote, please.
Mr. Chair, you have 19 ayes and 0 nays.
All righty.
Thank you, Mr. Chairman and committee.
Thank you, Chairman Butler. You are off to GovOps. We're going to take a break just for about 2 seconds because in my haste to make sure that we maintained order among the crowd today over yearbook signing, we missed Chairman Grills telling us about his special guest today in the crowd.
Thank you, Mr. Chairman. Avery C's with me today. He is from Stewart County. His dad is a state trooper. His mom's a nurse, and he is a senior. He's going to go to ATSU in Johnson City this year or later this year after he graduates. So y'all make him feel welcome.
And I know Representative Langford also has a guest here with us today.
Thank you, Mr. Chairman. I'd like to recognize Hayden Howell. He's sitting next to you, Chairman Grill's friend right there, and he's from Stewart County as well. Just make him feel welcome.
All right. Hope you young men enjoy yourselves today. Now we're back in action. House Bill 1677. Representative Eldridge, I see you up there.
Good to be here.
You are in proper posture, sir, but I see that there's an amendment that's traveling with you. Would you like to have it applied?
Yes, it pretty well rewrites the bill.
And is that the 015463?
Say that one again, sir.
015463.
I don't seem to have that one. I think I've got 14656. That may be an older amendment, though. It may be an older amendment, the number that I have.
Stand by, Mr. Sponsor.
Thank you.
Okay, all right. Mr. Sponsor, would you like to attach amendment number 1 coded 015463?
Yes, Chairman, I would.
All right, great. All those in favor of attaching 015463, please signify by saying aye. Any opposed, no. Ayes have it. Your bill is amended. Tell us what we do.
Thank you, Mr. Chairman. This bill is designed to aid our military families that get transferred into Tennessee. Their spouses may have a professional license. This is designed to streamline the process to get them back in the workforce as quickly as possible to help them with their family expenses. And as many of people know, I was not in the military, but my brother was and was transferred several times. And it was very difficult to get, his wife back in a job. So what it does specifically is it requires licensing authorities to display a specific notice on their websites and their applications related to communications and advertising that military families may qualify for recognition of an occupational license by another state. And that's basically what it does. This bill, I'm proud to say, picked up support from USAA and some of their efforts across the nation to do the same thing. So that's what the bill does.
All righty. We're enhancing reciprocation of licenses for military spouses and family members. Anybody have a problem with that? I think not. We shall vote on House Bill 1677 as amended. Madam Clerk, would you open the board? Madam Clerk, would you close it and call the vote?
Mr. Chair, you have 19 ayes and 0 nays.
All righty, and with that solid victory, Representative Eldridge, you are off to finance with House Bill 1677.
Thank you, Chairman and Committee.
Our old friend, Representative Travis, is joining us today. Got a House Bill 2175. We've got a motion and a second on your bill, sir. I see that there are several amendments that we have to choose from.
Yes, sir.
Would you like to give us the one that?
I would like to choose them all. Okay, the one that makes the bill is 14709.
All righty. Would you like to get all these attached before?
Please.
Okay.
Please.
Do I hear a motion in a second? All those in favor of attaching amendment 14709, please signify by saying aye. You would also like to see 015797, which
Yes,
is
sir.
amendment 2?
Yes, sir.
Anybody?
That just,
Motion and a second on that. All those in favor signify by saying aye. Aye. Any opposed, no. The ayes have that one. And then the last being 015960. Motion.
yes, sir.
All righty, we got a motion? Second. All those in favor of attaching 015960, please signify by saying aye. Aye. Any opposed, no. Sir, your bill is thoroughly amended. Would you please share with us about it?
Yes, sir. Thank you, Mr. Chairman and committee. It's good to be with you today. Currently, Tennessee law does not contain provisions regulating insurance coverage for delivery network companies, the DNCs. In 2015, the General Assembly under Speaker Cameron Sexton passed legislation creating regulatory framework for the transporting networks companies, which are the TNCs like Uber and Lyft, that requires to provide insurance coverage when a driver's policy excludes coverage or they fail to maintain said coverage. And this legislation models those requirements for DNC, whose services continue to grow with the expanded use of mobile delivery services. This bill provides a comprehensive regulatory framework and insurance coverage requirement for delivery network companies, the DNCs, operating in the state of Tennessee. The DNC maintains digital networks, the mobile apps, used to facilitate delivery services, which means the pickup of one or more products by the delivery network driver from a location and deliver of these products to a customer. Under this bill, the DNC or driver must comply with the following automobile liability insurance requirements: a DNC must ensure that during the delivery available period, beginning when a driver is operating a personal vehicle or is logged in to the app and eligible to receive requests for the delivery, primary automobile insurance is in place that does not exclude coverage for the use of personal vehicles to provide deliveries. And that I will answer any questions if I can.
All righty. Let me peruse the committee and see if I have some inquisitive minds. I think. Leader Cochran.
Thank you. And Representative, could you tell us, so the big difference between if this were to pass, the big difference between now and then. So currently, if I'm a DoorDasher, I'm covered from the time I click accept. So if an order comes in, I click accept, and I'm covered from that time till my delivery is complete, I think is maybe how it works currently. Tell us one more time how it would differ if this were to pass.
Well,
And excuse me, Mr. Sponsor, and if you could frame that in case Leader Cochran, Lord knows I thought I understood something and replied and I didn't understand it. But could you give us, from your knowledge, what the existing conditions are, which is so that we know where we are today and then where we are if the bill passes?
Thank you, sir. And Leader, answer your questions and to give you a little insight, if you're driving a personal vehicle on this job for the DNCs, if you don't have a commercial amendment, then your insurance could exclude an accident. So that's what we're trying to protect. So right now, if the app is on and you're delivering or available to deliver products or to get that job for the commercial use, then there's two things that's going to happen. The DNC is going to have to cover the insurance if your policy excludes, if your personal policy excludes that coverage from an accident. And that's where it all comes out is, when that app is on, you are available to take that job. So insurance companies could look at it as you are working on a commercial policy right now. And if you don't have an endorsement on your policy, your personal policy, they could exclude coverage, which means you would not have any coverage. You would be uninsured at that point. And it just mirrors what the transportation network is covered, what we did in 2015. So it just mirrors that policy.
Leader Cochran.
Okay, and so just for a little bit additional clarification, can you tell us what additionally would be required of DoorDash or other companies? I know DoorDash isn't the only one, but we'll just use them for the example. What additionally would be required of them after the passage of this bill than what is required of them now? What would change in their business model?
Mr. Sponsor.
Thank you, sir. Well, the business model now is the delivery network companies, whether it be DoorDash or Instacart or whoever it is, will use just the delivery network's services at this point. They already have what they call non-owned automobile insurance. That's what covers them while they're driving now. So that would be covered. The thing about it is on insurance is that if you have an accident, that insurance company, your personal insurance company, is going to find out, was it used, how it was used? Was it commercial use? Was it just an accident? And the DoorDash people would be, or the delivery network companies would also do the same thing. They would come together and say, who's responsible for this accident? Where is the coverage? Where does it lie? So I don't think there's anything that's going to change when we do this.
Okay.
All righty. Next up, Chairman Powers.
Thank you, Mr. Chairman. And we've been given some information. I just want to clarify this too. I realize Uber and Lyft have a certain liability limit, and DoorDash has a lower liability limit. That is not going to change at all. They're not going to be required to carry the upper limit like Uber and Lyft does, who have to carry personal private passengers, correct?
Mr. Sponsor.
Yes, Mr. Chairman, that is correct because, they're delivering a product and the other company is delivering a person. So the liability is more intense at that point.
Okay. All right. Thank you. Thank you.
Thank
Mr.
you,
Chair.
sir. Chairman Clemens.
Thank you, Mr. Chairman. So here's my concern and question. Let's say under this legislation, the driver has his app on, but accident happens, factual proof is taken. The driver was not involved in a delivery in any way, just happened to have the app on in the background of his phone. Now, under this bill, that would theoretically trigger that DNC coverage, right?
Yes, sir. If the coverage was excluded from the personal policy, it would.
Okay,
Chairman
so
Clemens.
that possibility exists. Now, if the liability carrier has the exclusion has that DNC exclusion, is this bill going to create a gap in coverage in the instance of factual proof showing the app is on, but he was not involved in a delivery at the time? Because that liability carrier's policy is going to exclude anytime the app is on or a delivery is being made under this legislation. But then the DNC carrier is going to come in and say, well, the app was on, but the factual evidence shows he was not involved in any way. It was an accident. He was actually on a date somewhere in another state or whatever, some other part of the state. Does that create a gap in coverage whereby there is no policy covering that instance?
Mr. Sponsor.
Thank you, sir. And that's a good question, but no, it would not create a gap, because if that person is not delivering for DNC, even though that app is on, you got to remember, if that personal policy excludes that liability, then that's where the DNC would come in and collect that thing. But most of the times, if you're driving, just going to town, going to the shopping center or something, and your app is on and you have an accident, your personal policy more than likely is going to pay for that claim, because it's not being used for commercial at that point.
But therein lies the problem with the legislation, because this legislation says the DNC policy is triggered when that app is on. And the DNC insurance defense, I can guarantee you, in that instance, is going to come in and say, well, the app was on, but the facts show that he wasn't involved in delivering in any way. We can't be held liable. And meanwhile, you've got the liability carrier has that exclusion that says anytime that app is on or anytime, they're making a delivery, we are not liable. And so you're going to have this insurance versus insurance war and questions of fact and legal debate about something that I'm afraid is not clear enough in the law as it is. I like the bill. I think it's, like I said last week, I think it's fascinating, and I think it's a great thing to cover. I just worry about there being a gap created by a dispute of the facts between two insurance companies. Meanwhile, you've got the injured party out there, or the driver, the insured, that's getting drug along for years while two insurance companies do battle and their lawyers bill by the hour. That's my concern.
Mr. Sponsor.
And I can see where you're coming from, Representative Clemens. But let's go back to 2015 when we created this with the transportation network companies. I have no idea where there's any claims that's happened like that that's been disputed. But you got to go back to insurance also. If you're driving your personal car and you have an accident with me, the insurance company is going to look at, was I 30% responsible? Were you 70% responsible? So where does that lay in the insurance coverage right there? So there's always disputes in any kind that can happen in the insurance, but I don't see anything like this. It's going to be a concern.
Chairman Clemens, you good or?
Oh, I just wanted on the record, you do not believe there will be a gap in coverage created by this legislation?
I do not believe there will be a gap in coverage. So.
Thank you, Mr. Chairman.
All right, thank you. Chairman Lafferty.
Thank you, Mr. Chairman. So help clarify this in this example I'm going to try and give. I wake up in the morning. It's my understanding how these services work. I can pick and choose. I don't have to, just because a delivery comes up on the screen doesn't mean I have to take it. It may be geographically difficult. It may be on the other end of town during rush hour. I wake up in the morning, I click on, I'm available for deliveries. I'm looking, I'm not taking these orders. I decide to run down to my local coffee shop for my bagel and coffee. I get in an accident. Who's picking up the coverage right there?
Mr. Sponsor.
Thank you, sir. Okay, what you said is perfect. So you get up in the morning and you click on that app to go to work. That's what you're doing. You click on the app, you want to go to work for a delivery company. That's what you've said that you were just going to do right there. But you don't take a ride or nothing's available and you go down for the coffee, your personal insurance would pick you up at that time.
Okay. So I'm on the app.
Jim.
It is activated, but because I have not accepted a delivery or accepted the responsibility of picking one up, then it's still my personal insurance.
Yes, sir.
Okay.
That would be correct. You're doing a personal insurance. What we're trying to do is to protect you or your family that's going to get on that app, take a delivery, and then your personal policy says there's no coverage. So you're out there with no coverage whatsoever. Whoever you hit, whatever you do, you no coverage. So that's what we're trying to do. Just with the TNC right now is the same way it will be with a delivery network companies.
Okay. So just to clarify, I've got the app on. I have not accepted that I'm going to actually take a delivery. The app's on. I get in the accident. My insurance is responsible, not the company's. That's.
You said you were going to the coffee shop.
Yes.
That is correct. You're going to the coffee shop. You're doing personal time on the coffee shop. Now, if you have that app on and you're driving around town waiting for that delivery pickup, it could get a little, what Representative Clemens was talking about. It could be in that zone where do the insurance companies come in at this point? What is it, a personal claim or is it a commercial claim?
So Chairman Lafferty, just if you could wrap yours, if you could get it comfortable, if possible, if not, just wrap it up and we'll move on because others have other questions.
Let's wrap it up, move on. Thank you, Chairman.
All right, thank you. Speaker Marsh waved me off. Representative Vital waved me off. Representative Lynn.
I had the same question as Representative Lafferty, so thank you.
Thank you. And I got Leader Cochran. You've piqued his interest with a reply there. So let's go to Leader Cochran.
Okay, thank you. And sorry, just to belabor the point, but in your response to Chairman Lafferty, let me just clarify again on the scenario that he presented. And so let's look at on page 1, section 1 of the amendment. So as used in this section, delivery availability period means the period when a DNC driver is operating a personal vehicle. And then item B, I think this is the important clarification, has logged on to a digital network and is available to receive requests to provide delivery services from a delivery network company. Am I misunderstanding something? Because it sounds like as soon as you log in, you are then covered by DoorDash. It doesn't say that as soon as I've accepted a delivery. The way that the language of the bill says, as soon as I've logged in to a digital network, I'm then considered in the delivery availability period. Am I misinterpreting or misunderstanding something? Because it sounds like what the scenario that Chairman Lafferty presented. If I wreck, and even though I haven't accepted an order yet, at that point the company the DoorDash or whoever has to then cover my wreck. Am I misunderstanding that?
Mr. Sponsor?
Again, it's mirrored to do the transportation network company. So if you log in, that means that Instacart, DoorDash, or whoever could be responsible for that accident if you're out there looking for work. If you're going out for a cup of coffee or something and you turn that application on and you haven't picked up anything, that I think would be going back to the personal insurance. But what we talked about a while ago is that when those personal insurance companies or that commercial insurance companies to get together, That's where they're going to determine what policy is active at that time.
And then just one final, and so if you don't mind, just to look on that language there, and then also item C, it says is not providing delivery services or operating in the delivery service period, that they are still considered in the delivery availability period. That seems to conflict maybe with an earlier answer. But again, I'm not saying that I'm not misinterpreting it, but looking at those bullet points, that seems to provide some confusion there.
Mr. Sponsor, I think in this instance, because I know that the worst thing you can do is call for a vote on a confused committee. And the more we've gone around on this, the more concerns have driven. My suggestion to you would be, let's roll this to the heel. We're going to be back next week. We can get specific questions addressed and have them referenced to the amended bill as it's before us, so that everybody here can feel good about exactly what it is they're voting on, as opposed to an interpretation time. We're going to be same bat time, same bat channel. We will be here, sir. Mr. Sponsor, I don't want to put you up for a vote today.
No, I got you. But what I would like to do too is have someone come that knows a little more about how all this works to speak next time about this coverage gap that you're looking at.
All right. Well, I think then we will, without any objections, then we're going to roll House Bill 1723 to the heel of the final calendar. 2175, excuse me. We haven't got to 1723 yet. Roll to the heel. But just because we're rolling that one to the heel doesn't mean you have to go anywhere.
I'm not going anywhere.
All right, Representative Travis, House Bill 1723. We got a motion and a second. All right, sir, you have an amendment. Would you like to attach your amendment?
Yes, sir, please.
All right, that's Amendment 013625.
That is correct.
Got a motion and a second. Without any objection, we're going to vote on the amendment. All those in favor signify by saying aye. Any opposed? No. The ayes have it. Your bill's amended, sir. Please talk to us about online content creators.
Thank you, sir. This is about child labor. Now, child labor laws was written many moons ago before social media come into play. So this is going to try to protect our children. It requires a content creator whose video content features a minor who is 14 years age or older, but under 18 years of age, to be engaged in the work of content creation to maintain certain records until the minor reaches 21 years of age. It requires a parent or other adults who feature a minor in video content to share it on an online platform for compensation to set aside an amount of the gross earnings on the video content into a trust account for the minor. It authorizes a minor to commence civil action against a content creator for certain violations. Requires the video content containing the likeness of a minor to be deleted and removed from an online platform if requested by a minor who is 14 years of age or older, whose likeness appears into the content. And it requires a social media platform to develop and implement a risk-based strategy to help mitigate risk relating to the intentional sexualization of known minors. And with that, I'll take any questions.
Any questions? Any questions for our sponsor? Seeing none, hearing none. Let's vote on House Bill 1723. Madam Clerk, would you open the board? Please close the board and call the vote, please.
Mr. Chair, you have 18 ayes and 0 nays.
Thank you, ma'am. With that vote, Representative Travis, you are off to calendar and rules with House Bill 1723.
I just wish my other bill looked that pretty. Thank you, sir.
We comprehend some ideas quicker than we do other ideas, Mr. Sponsor. Representative Hill, see you back there. Come join us. No, excuse me, sorry. Representative Gant. Carry on, Representative Hill. Representative Gant, you're up. Let's just hope we don't have a delivery network company bill from you, sir. All right, Representative Gant, you're recognized on House Bill 1760. We've got a motion and a second. Do we have, you want to get that amendment on there?
Yes, sir.
All righty, is that coded 015539?
That's correct.
All right, I've got a motion and a second. All those in favor of attaching 015539, please signify by saying aye. Any opposed, no. Amendments attached. Tell us about your amended bill, sir.
Thank you, Chairman and Committee. This will be real quick, and I'll let you get to Mr. Hill rather quickly. All this is transparency and predictability of an inspection company that if an applicant chooses to use a third-party inspector for a locally required building inspection, they must use a third-party inspector for the subsequent inspections as well. So what that means is if you start out with a third-party electrical inspector, you cannot go back to like the city or the county and use their inspector. You have to carry that out with the completion of that project through that third-party inspector that you started with.
All right.
Just bringing clarity.
Got it. Do we have any questions for the sponsor? Seeing none, hearing none. All those in favor of moving 1760 on to calendar and rules, please vote aye when Madam Clerk opens the board. Thank you. Madam Clerk, close the board, call the vote.
Mr. Chair, you have 18 ayes and 0 nays.
All right, and with that, House Bill 1760 is on to calendar and rules.
Thank you, Committee, and thank you, Mr. Chairman.
Chairman Hill, Representative Hill, good to see you. Sorry for the false start earlier.
That's all right.
You
Thank
could have
you,
thrown a legal procedure penalty on me there.
That's all right.
House Bill 2617. You got a motion and a second to recognize, sir.
Thank you, Mr. Chairman. This legislation directs the administration to approve short-term workforce training programs for the workforce Pell Grants, pending that they meet federal eligibility requirements. And the goal of the legislation is to try to get those individuals that are seeking an education, be able to get those dollars to them quickly so they can get in the workforce faster. And pending any questions, I seek passage.
Outstanding. Do I have any questions for Representative Hill? House Bill 2617. Representative Vaughn.
Thank you, Mr. Chairman, and thank you, sponsor, for bringing this. With more and more of our community colleges and TCAP programs offering certificates, this is a real good opportunity to help with the rising costs of education. Thank you.
Thank you, sir.
Any further questions? Seeing none, let's vote on House Bill 2617. Madam Clerk, would you open the board? Let's close the board and call the vote.
Mr. Chair, you have 18 ayes and 0 nays.
Thank you, ma'am. And with that, Mr. Sponsor, House Bill 2617 is off to finance.
Thank you, Chair. Thank you, Committee.
I'm gonna take a little privilege here. We're gonna deal with Representative Love. We're gonna take him out of order. Then we're gonna come back to Representative Leatherwood because there's gonna be a lengthier discussion on Representative Leatherwood's that will probably spill over into our next meeting. And then the rest of it is just us home folks, and we'll take care of that during yearbook signing day. All right, everybody got that? That sound like a plan for everybody? So we're going to recognize Representative Love on House Bill 1946. Motion and a second. I see we've got an amendment. Representative Love?
Yes, sir, Mr. Chairman. I think it's 014031.
That's what we've got. We got a motion, got a second on the amendment? All those in favor of attaching amendment coded 014031 to House Bill 1946, please signify by saying aye. Any opposed, no. Your bill's amended, sir. Please tell us about it.
Thank you, Mr. Chairman, committee members. We are all aware, I think, of the impact that artificial intelligence is having upon our community. And this particular piece of legislation simply would direct TASER to study the existing federal laws and pending federal regulations, also to look at potential impact fiscally on state and local governments, and also look at the economic impacts on businesses, technology developers, educational institutions, and certainly the safeguards relating to minors and mental health protections, including suicide prevention protocols. And Mr. Chairman and members, that's simply what the bill does.
Thank you, sir. I think it dovetails with the first item on our agenda today, but that's one man's opinion. Anyone have any comments or questions for the sponsor? All right, let's just vote on this thing. Madam Clerk, would you open the vote? Please close the board and call the vote.
Mr. Chair, you have 22 ayes and 0 nays.
And with that, Representative Love, you will be off to Finance.
Thank you, Mr. Chairman, committee members.
All right, Representative Leatherwood, you're recognized on House Bill 1777. Got a motion and a second, sir. You want to put your amendment on?
Yes, sir. That would be Amendment 015515.
All right, 01555. Do I hear a motion and a second on the amendment? Got a motion and a second. All right, sir. Let's vote. All in favor of attaching amendment number 1, coded 015515 to House Bill 1777, please signify by saying aye. Any opposed, no. Ayes have it. Your bill is amended, sir. And would you like to get started, or would you like for me to go ahead and, well, give your introduction to it? We've got 2 or 3 minutes here. Let's get started.
Okay, I'll go ahead and get started. Over the last few years, 3 of my 5 daughters have bought homes. Each of them at one point or the other was outbid while trying to buy the home from a REIT. This led me to do a word search in our TCA and surprised to find out that we give REITs a tax break that we don't give to other businesses. All rental companies are not REIT rental companies. They don't get this tax break either. What this bill would do is remove those tax breaks and advantages that the REITs specifically get. And it only impacts REITs. It does not impact an individual that has a rental home or a business organized in a different fashion that rents homes. So with that, I would appreciate y'all's support. President Trump has passed an executive order to try and address this issue, and the Senate this week passed legislation to try and address this issue. Thank you.
All right, thank you. And this matter has, I think we need to talk about clarity, though, within the words within the bill, because whenever there's one side of looking at this, and that is that we're out to protect the young home buyers who are having to compete in the marketplace with these large unnamed REITs. But at the same time, your bill also does some other things that it expands beyond single family dwellings. It expands to multifamily REITs. It expands to all buildings, commercial buildings owned by REITs. It also says that for the first time, I think, in our code, we would be taking residentially used property and applying a 40% or a commercial assessment value on it, as opposed to what the residential rates are, which is a significant change in what we're doing with taxation in our state. And so and I'm one that also believes that at the end of the day, whatever tax we pass on to a landlord will eventually be paid by the tenant. Particularly in cases such as on the commercial buildings that's included in your bill, those rates are many times the commercial leases are triple net leases, and it would be immediately passed on through to the tenant. So I think your bill could use some work to get it to mirror what you're purported to wanting to do on it. So I would really encourage you, before we go into too much discussion on this, that it might be best to take a little time, let it marinate, and come back next week and talk about some of these particular issues, because, it affects all of us, that whenever we're governing and we see a fiscal note that looks like we're going to bring in $75 million recurring into the state treasury, we say, wow. And if we're taking it from a tax break that has not been considered in taxation policies before, that would be a big win. But at the same time, it also looks an awfully lot like we're going to raise people's taxes. We're going to raise investors' taxes by $75 million annually. And that's the converse of this, while that's going to be passed on to consumers. So I would say in this instance, much like our delivery network company bill, that maybe a little bit of time on this and some clarity, because the REIT investment vehicle has been around for quite some time. And I'd like to hear from some folks about whether or not do they receive a tax break, or are they taxed differently? Because sometimes they may not be taxed less, they're just taxed differently. All those questions I've got, and I'm sure that my colleagues have also got some of those. So if you don't mind, Representative Leatherwood, rather than vote that today, I think probably we need to roll this one to the heel of the calendar, and we take that up next week. What do you think?
I'd like to address some of what you brought up. I do think it's a pretty clear and simple bill. Yes, it deals with all REITs, and REITs do own property beyond single-family homes. But businesses organized differently than REITs also own businesses other than single-family homes. And they are at a disadvantage because they don't get the tax break. So this is a tax break exclusively for REITs. Again, it doesn't impact, this bill would not impact individuals who have rental homes. It would not impact other businesses that have rental homes or don't have rental homes, because these businesses and individuals do not get the tax break. It's exclusive to REITs, and it does give them an unfair tax advantage, competitive advantage against not only individuals, but other businesses as well. As far as passing the cost of leveling the playing field here onto their renters, right now, again, all rental companies are not REIT rental companies. They are in the business without this tax break, and they're having to set their rent based on the current market.
Thank you, Mr. Sponsor. Deputy Speaker Zachary.
Motion to adjourn.
That's not a debatable motion. All those in
That's
favor
fine.
say aye. We will take up the remainder of our calendar next week. Thank you.